Yes, Judge.
And we're back on YouTube. This is cause 657-729, Theta, Texas versus Daniel Trevino, represented by Mr. Kelly Pittle. First document I have in this case is entitled Defendant's Consent to Plea by Video Conference, which purports to have both Mr. Trevino and Mr. Pittle's signature on it. In fact, Mr. Trevino, is this your signature on this document, sir?
Yes, sir.
Thank you. And Mr. Pittle, as attorney for Mr. Trevino, is this your signature on this document, sir?
Yes, Judge.
Next document I have is entitled Defendant's Waiver of Constitutional Rights and Court's Admonitions, that purports to have your signature on the back, effectively waiving certain constitutional rights you must waive in order to enter a plea before this court. In fact, Mr. Trevino, is this your signature on this document also, sir?
Yes, sir.
By signing this document, are you telling me that you've had enough time to either read this document or have it read to you in its entirety? If you had any questions about what was on this document, those questions were answered to your satisfaction by your attorney, so that in signing this document, you're telling me that you agree with and understand everything on this document. Is that correct, sir?
Yes, sir.
Thank you. Mr. Pittle, as attorney for Mr. Trevino, have you had enough time to go over this case with him, and in your opinion, is he mentally competent?
Yes.
Mr. Trevino, are you a United States citizen, sir?
Yes, sir.
Is that yes? I'm sorry.
Yes, sir.
Okay, thank you. And Mr. Pittle, has the state fully complied with discovery for you on this case?
Yes.
Any motions on this case, state? Starts out as a DWI first and stays a DWI first. Are we all in agreement?
Yes.
Mr. Trevino, on clause 657-729, is that the number that's kind of, yeah, that's right. To the charge of driving while intoxicated, first offense, how do you plead, sir?
No contest.
Is there an agreement for Mr. Trevino?
Hello.
Who's our ADA on this one? Mr. Sanheinrich or Ms. Sanchez?
Good morning, Your Honor. I believe Ms. Sanchez is.
Do you have a plea bargain on Mr. Trevino's case? Karina, are you involved in this one?
I can tell the court.
I think she needs a moment, Judge.
I think she's having audio problems.
Take your time.
Thank you, Your Honor.
Can you hear me, Your Honor?
I got you.
Okay, sorry about that, y'all.
No problem.
Yes, Judge, there is an agreement. The agreement is a $0 fine with court costs, 22 days in the Bexar County Jail, credit for time served, time and money to run concurrently, and if it pleases the court, the judgment would be satisfied.
That's not the plea bargain, Judge. It's a 1-year deferred adjudication. It's in synopsis in JD.
Okay, one sec, Judge. I apologize. Hold on 1 second.
Sure.
Actually, I don't have the agreement on this, Judge.
Let me read off what I've got. The DA's apparently sent this to me. It could have been you or it could have been John. This is what I understand the plea bargain to be. 1 year deferred adjudication on DWI first, $500 fine plus court cost, 60 hours community service, DWI education, DWI victim impact panel, CATSNP, ATSE. Does that mean shoplifting or APSE? I'm not sure. This one says ATSE.
It should be the alcohol evaluation, Judge. I may have written it down wrong.
Maybe that's alcohol treatment evaluation. All right, we don't do that.
I think it should be the CATSNP, Judge. The ATSE is supposed to be CATSNP.
Gotcha.
Well,
And the Smart Start Mobile or Life Safer home interlock at 4 blows a day for 6 months, which is half the term, and $180 reimbursement to the Texas Department of Public Safety for lab fees. That sound right, Mr. Piddle?
Correct. It's not supposed to be a CAT sniff. What we're trying to, it should be ATP evaluation or whatever the court does in that.
We don't use ATP evaluations because they're worthless, but
Okay.
other than that,
Judge, he's going to get a TAP evaluation with his felony. So that he's going to be sent to some immediately after this.
all right, well, here's the deal. I'm going to order catnip because we do that on everything, which is our outpatient drug course. If he gets an outpatient drug course or any drug course with a felony, get back to me, and probably it will be more heavy duty than the one we've got. But a lot of times defendants have to wait a year to get a TAP evaluation, and we're not waiting. So he needs to initiate outpatient drug with us if the felony is not going to do it immediately.
Okay, Judge.
All right,
And Your Honor, this is supposed to run concurrent with the felony.
That's correct.
you have a felony number?
Yes, Judge. One sec.
It's
Kelly, you got a felony number?
Yeah, it's 2022 CR 0698.
2022 CR 0698. Does that sound right?
Correct, Judge.
All right, let's go over this one more time. The court accepts Mr. Trevino's plea of no contest to the offense of driving while intoxicated first offense. Although I have enough evidence to find him guilty, I'm going to withhold a finding of guilt. Place him on 1 year deferred adjudication probation. It says a $500 fine plus court costs, 60 hours community service, DWI education, DWI victim impact panel, community alliance for traffic safety new intervention program, either a Smart Start mobile or a Life Safer home interlock at 4 blows a day for half the term, which is 6 months. This case to run concurrent with 2022 CR 0698 and a restitution of $180 to the Texas Department of Public Safety for lab fees. And once again, I'm advising the defense, if the felony case probation assesses some sort of greater outpatient or inpatient drug program, get back to me and I can waive this one. I don't want them going to 2 separate drug programs, but my guess is it's going to take them a lot longer to implement than I can. So that's where we're at. Anything further from the state or the defense on Mr. Trevino?
Not from the state, Judge.
Not from the defense.
All right, good luck, Mr. Trevino. Thank you, Mr. Piddle.
Thank you, Judge.
Thank you very much.
And are we ready on Mr. Solis?
Judge, if I may give Mr. Piddle some instructions?
Sure, that'd be great.
Okay, give me just a minute, please.
While we're waiting, Victoria, what have you got?
Your Honor, I have 2 defendants. They are on full GPS, and they are both here in the courthouse. We would like to approach to consider, for your consideration, to switch to tracking only. They are on full GPS, and they both have dire financial need to work, Your Honor.
Okay, here's my problem. I have no access to the file, so I have no idea what their background is or why I would have initially ordered full GPS on them. But if you give Pat or me their names and case numbers and perhaps SID numbers, I can research it and hopefully get back to you before the end of the day.
Yes, Your Honor. Would you like that in the chat, or do you want that in an email?
Why don't you send it to me in email to wchristian@bear.org.
Yes, Your Honor. I will stand by.
All right, thanks.
Thank you.
And what are we waiting on at this time?
I don't know.
Pat, are you with us?
Yes, sir. You're able to go.
All right, are we ready to proceed on Mr. Solis?
Yes, Judge.
This is cause number 664786, State of Texas versus Benjamin Solis. This is a first amended motion to enter adjudication of guilt and revoke community supervision. And representing Mr. Solis is going to be Ms. Suzanne Kramer. Representing the state is Mr. John San Heinrich. And Ms. Karina Sanchez. Representing the Bexar County CSCD is Ms. Susan Gross, who I will swear at this time. Ms. Gross, please raise your right hand. Do you swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. The first document I have on this case is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which purports to have both Mr. Solis and Ms. Kramer's signature on it. In fact, Mr. Solis, is this your signature on this document, sir?
Yes, sir.
Thank you. And Ms. Kramer, as attorney for Mr. Solis, is this also your signature on this document?
Yes, Judge.
The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication and the defendant has a limited right of appeal. Is this your signature on this document also, Mr. Solis?
Yes, sir.
And Ms. Kramer, as attorney for Mr. Solis, is this also your signature on this document?
Yes, Judge.
Ms. Kramer, my understanding is that this is going to be an uncontested first amended motion to enter adjudication of guilt and revoke community supervision. Is that correct?
That is not correct, Judge. I spoke to Mr. Solis and gave him the options. He wants to plead not true to all allegations, and he does not wish to reset it for a hearing to require the state to bring in their witnesses to be able to prove up these allegations. He wanted to plead his own case to you. I did give him the, the lowdown on why that might not be such a great idea, but that's what he wants to do.
All right, let me clarify for the record what I think we're doing. First off, Mr. Solis has an absolute right to request what I call, I don't think this is a term that's spelled out in the Code of Criminal Procedure, a formal contested first amended motion to enter adjudication of guilt and revoke community supervision. And normally what that entails is the only variation on the theme between having a formal contested first amended motion to enter adjudication of guilt and revoke community supervision and a normal one wherein the defendant can enter either a plea of true or not true, and then obviously I'm going to make a decision whether I think they're true or not true, is that we try to call on a formal contested hearing the original probation officer on this case. Susan, is that your understanding of how that works?
Yes, Your Honor.
Okay, so at this point in time, it's my understanding that Ms. Kramer, as attorney for Mr. Solis, is letting us know that they are not requesting a formal contested first amended motion to enter adjudication of guilt and revoke community supervision, but that the defendant would like to enter a plea of not true to all allegations on the first amended motion to enter adjudication of guilt and revoke community supervision. And ultimately, I will make a decision on that and find whether they are true or not true. Is that correct, Ms. Kramer?
Yes, Judge.
Okay. Mr. Solis, in cause 664786 on the first amended motion to enter adjudication of guilt and revoke community supervision, how do you plead, sir?
Not guilty.
Thank you, sir. The court accepts the plea of not true to all conditions. Ms. Gross, would you please advise the court and the parties of the status of Mr. Solis' probation?
Yes, Your Honor. Mr. Solis has been reporting as directed. We last saw him on June 6, 2022. He has paid $300 toward his fees. He has a balance of $1,299 and is currently delinquent $208. He has completed 32 of his 48 hours of community service. He has also completed DWI education, victim impact panel, and the CATSNP program. His drug testing has resulted in 1 positive drug test for cocaine and 2 negative drug tests. He is currently on the Smart Start mobile testing it 4 times a day. Since he was placed on probation March 24th of 2022, he has had 15 skip tests and 1 high BRAC, which occurred on May 31st, 2022, and registered at a 0.045 at 10:57
PM.
Yes, PM, and he did not blow to clear until 12:15 the following day. This is his first violation report, first MTR. He has no criminal history. His officer is recommending that he be placed on a SCRAM device for 90 days and that he enroll in a drug offender education program within 10 days.
Mr. Kramer, to isolate the issues from my perspective, We've got one positive for alcohol, which would normally be addressed by increasing his loads on the Smart Start mobile. The cocaine allegation is a more serious situation, and since we don't really have access reasonably to an inpatient drug facility in Bear County at this time, what is your position on that?
Well, and Judge, also, Susan, real quick, in the first motion to revoke, it does look like he did blow again at 11:06 after the 10:57 blow. And the alcohol amount was going down, so he did blow again.
Right, but it didn't blow to clear until the next day.
Okay. He absolutely says that there's just, I mean, he's been doing so well. He gets put on probation in March, and by this time, he's already finished all his classes, and he says he was trying his best to do as well as he could, and there's just no way he could possibly have intentionally ingested any cocaine. So he's just absolutely flat out denying that. I would, the scram device certainly will on a zero tolerance will let you know if he's falling off the wagon on that kind of stuff and is getting it in his system, and then you can just throw the book at him. But he seems to be genuinely not understanding how he could, because he did do a confirmation. Now, I didn't get any notification of what that result was, Susan. I guess it was positive. Otherwise, this wouldn't have been filed.
Judge, I spoke with the officer yesterday in regards to whether or not the defendant had been ordered to go and get a confirmation. The officer stated that she did order the defendant to go do that. And however, she could not confirm that the defendant had gone and made the payment for a confirmation. I too looked in the computer system where it updates and shows that a defendant has paid for confirmation. I did not see any receipt in there for a confirmation for that cocaine to be retested.
Okay, who has the authority to order a defendant to get a confirmation test that he has to pay for out of his pocket? I don't think probation department has the authority to do that. We normally tell them they have that option if they want to do it. Does that not sound how it normally works? I've never heard of anybody ordering somebody to get one.
Well, it wasn't an order. It was highly suggested that if he wanted to prove his innocence, that he go and pay for the confirmation. That's the way it's always put to the defendants. It's not put to him as an order.
All right, that's not what you said. It's okay. I got it.
And Judge, he informed me that he went to get this confirmation, so I don't know anything more than that. So I just assumed, since the MTR was filed, that it was amended, that it came up positive. So if he didn't do that, then there that is. I don't know.
Let me, do I have your permission to chat with Mr. Solis about this confirmation issue?
You do.
Hey, Mr. Solis.
Yes, sir.
Did your probation officer tell you that you had an opportunity to send for confirmation for the positive drug test for cocaine?
Yes, sir. And I went the very next day. She had told me that.
And did it cost you some money to do that?
Yes, sir. She told me on the phone it was going to cost me $15, but when I went and told the workers there, like everything, it charged me $20.
All right. And so who did you pay $20 to?
It was to the front office. So when you check in, and when you go to the drug test or to the UA analysis on Commerce Street.
All right. And do you recall approximately what date that was?
I believe it was the 22nd.
Ms. Gross, if he truly did that and there's a confirmation test out there somewhere, how do we find out the result?
Judge, as I stated, the officer has looked for it. They have reached out to NORCAM. They've got no response, and I am pulling it up again right now to see if there is any new notations in the system. So give me about 15 seconds and I'll have an answer for you if there's anything in the system.
And if I could just say one thing, I got the receipt after I was done. I even emailed it to my PO, just like if it was a normal drug test.
Thank you, sir.
Yes, sir.
Mr. Solis, I'm going to ask you to turn your microphone off when we're not specifically talking with you. We're getting a lot of jail background noise. Thanks, sir.
All right, Judge, I am on their website right now and I do not see any receipt in there for confirmation or having a confirmation having been done. And if he went the day after the positive result came back and paid for it at that time, it would have been back by now. And there's nothing in the computer system.
All right, so you can not confirm that the defendant actually paid this money and asked for a confirmation test? Is that what you're telling me?
Correct. I cannot confirm that.
That doesn't mean he didn't do it. It just means that the probation department can't confirm it at this time. That makes sense?
Correct.
Okay.
I can see about getting the officer on Zoom real quick if you would like to question the officer about that.
I just want to know, I think Mr. Solis and Ms. Kramer and the DAs and I would just like to know what the result is of a confirmation test. If there was a confirmation test, and if there wasn't a confirmation test, and Mr. Solis paid his $20, I thought they were like $35 for a confirmation. How much is a confirmation test these days?
I believe they're $20.
Okay, well then there's the right amount. See if you can get her, let's take a quick break and let Ms. Gross try to track down the original probation officer and see if she knows anything more than we know. I find that a critical piece of evidence that we need to know about. Ms. Kramer, do you agree?
Absolutely, Judge.
Okay, let's take a break, guys.